And yeah, please be distributed evenly. Guys at the back, and it's more so because the photograph will look good. And be sure you would not be allowed to leave the hall until Justice Patnaik is here in the house. So there is absolutely no special benefit of staying close to the exit gate. Please move towards the side. Look good. Start moving. Yeah, that's more like it. Thank you so much. We'll start in a couple of minutes.
A very good evening, everyone. It is my privilege to welcome you all to the first Madhusudan-Soudamini Das Memorial Lecture, a heartfelt tribute to the enduring legacy of Sri Madhusudan Das and Srimati Soudamini Das, visionaries whose contributions to education, social reform, and nation building played a defining role in shaping modern Odisha and continue to inspire us. May I now request our esteemed dignitaries to kindly grace the dais. I would now request our esteemed speaker, Justice Ananga Kumar Patnaik, to please take his seat. I request Professor H.N. Ghosh, Director NICER, Dr. Pranay Swai, Registrar NICER, and Professor Jain Maharana to please grace the dais. And as we begin today's program, I now invite our students to present the invocation. Before, as they do their setups, now I would request the honor of presenting the floral bouquets to our dignitaries.
सर्वेषां नो जननी भारतधरणी कल्पलतेयं जननी वत्सलतनय गणेश सम्यक् शर्म विधेयम् सर्वेषां नो जननी भारतधरणी कल्पलतेयं जननी वत्सलतनय गणेश सम्यक् शर्म विधेयम् सर्वेषाम् सीमन्तितमस्तकमिदमम्बुधिपरिगतपार्श्वम् अस्मज्जन्मदमन्मदमनिशं श्रोतपुरातनमाशम् हिमगिरिसीमन्तितमस्तकमिदमम्बुधिपरिगतपार्श्वम् अस्मज्जन्मदमन्मदमनिशं श्रोतपुरातनमाशम् विजनितहर्षं भारतवर्षं विश्वोत्कर्षनिदानम् भारतशर्मणि कृतमस्माभिः नवमिदमैक्यविधानम् सर्वेषाम् भारत पङ्कजदलमिदमुत्कलमण्डलमिति विदितं यत् तस्य कृते वयमत्र समेता विहितात्रोत्कलसंसत् भारत पङ्कजदलमिदमुत्कलमण्डलमिति विदितं यत् तस्य कृते वयमत्र समेता विहितात्रोत्कलसंसत् भारतमेकागतिरस्माकं नापरास्ति भुवि नामा सर्वाणोपनिषत्कर्मणि तु भारतमेव नमामः भारतमेव नमामः भारतमेव नमामः.
Thank you. Thank you so much for the beautiful invocation. This invocation bears a deeper resonance with Sri Madhusudan Das, one that I shall refrain from unfolding at this moment. I invite you to hold the thought as Professor Jain Maharana will illuminate this connection during his address on the genesis of lecture. Moving on, may I now invite Professor H.N. Ghosh, Director of NISER, to deliver the welcome address.
Good afternoon, everybody. Welcome to NISER. Justice Ananga Patnaik, Professor Maharana, Dr. Pranay Swine, and all dignitaries. I mean, I can see a lot of physicists here. We have also some lawyers. And our faculty and students. This is a very important meeting. I know every time we call lectures for the scientists, who is physics, chemistry, biology, and they give a lecture. So this is something different, which is very, very important. And I must thank Professor Maharana to constitute this lecture, Madhusudan-Soudamini Das Memorial, because every year we are going to listen something about the Indian judiciary system by many important justice or lawyers, and which is very, very important. In the social media age, actually the young mind are, their mind are diverted and doing a lot of things or thinking a lot of different direction. At this crossroad, I think it is very important. This lecture will tell us like how to take the life beyond science or whatever. If you see that this institute basically academic institute of physics, chemistry, math, biology, all natural sciences, but our social science department of late getting stronger. I mean, it's very important to have idea of social science, economics, and English and other things, and we are hiring more and more faculty. It's going to be strong. So this is age of interdisciplinary or multidisciplinary research. It is also very important to know what is the social justice. So today, sir will tell us, the title, the fundamental rights of the Indian Constitution is very, very important. I don't know how many of you actually think about the Indian Constitution. In the social media, you read something and write something. We should be very, very careful. Today's lecture will actually give a teaching that what we should think about it and which direction we think it. Thank you very much, sir, for accepting this lecture, first lecture in our institute. And our young mind, our faculty actually will be enriched. And eventually, it will be every year the lectures, this kind of lectures will come and will be attached with the social system, social justice in this country. I'm not going to talk much. I mean, as a faculty of physical science or chemistry, I mean, whatever I think about the social justice system, I just talk about it. We grew up from villages and then come out to the school, and then through your journey, you encounter with a lot of new things. Actually, when you come from a village, go to school, and all kind of social justice and injustice, you can see that. I think it is very, very important for everybody, not only our students, every faculty. You should think back and think about what is Indian Constitution, think about it. So I'm going to end here, and thank you very much, Professor Maharana, to constitute this lecture. And I'll take the, on behalf of NISER, we welcome our today's speaker, actually, Justice Ananga Patnaik. Thank you very much.
Thank you so much, sir, for your encouraging words. I now invite Professor Jain Maharana to address the gathering and share the genesis of the Madhusudan-Soudamini Das Memorial Lecture. Please.
Can you hear me? Professor Ghosh, Honorable Justice Patnaik, distinguished guests, faculty members, scholars, young students, the members of the print and electronic media, ladies and gentlemen. I'm honored and privileged. I stand before you with humility. I shall be very brief. The opening song was composed by Radhanath Rai when Madhusudan-Das asked him to compose a song for the first Utkal Sammelani in 1903. And you heard the song. Then in 1961, the annual Science Congress was held in Ravenshaw College. And it is to the wisdom of the organizers they rendered the song. Jawaharlal Nehru was presiding over the meeting, and in his speech, Jawaharlal said that this song is fit to be the national anthem, but nobody brought this to our attention. It is just like Ettore Maharana died, and so many papers are written about Maharana Fermions, and so many experiments are done. That is the fate of Radhanath Rai. So I am really very happy that after all these years, on this forum, this song is revived. I hope nicer in many occasions will render this song. So I don't want to spend much time talking about Madhu Babu. Will be like shining a torch to the sun. So this little presentation will be like that of a talk of a physicist. Okay. So first question is, why Madhusudan-Soudamini Memorial Lecture at NICER? NICER is a National Institute of Excellence, and it has established its footprint in India and abroad in good institutions. The faculty, student, and staff members come from all parts of India. It is a cosmopolitan organization. It's all in capital, so it will be long. They will be curious about art, culture, music of the state. They will be curious to know why roads, bridges, colleges are named after this man. Everywhere, why? This is Madhusudan part one. Okay. Who and why is Soudamini Das? You go to any meeting on Madhusudan-Das, you never heard name of Soudamini being ever uttered. Many people ask me, who is Soudamini Das? I said, please wait 24 hours. So, Madhu Babu became a Christian in Calcutta after he passed his BA degree. Before that, in Orissa, scandals had spread that to marry a Christian girl, he had converted to Christianity. And even Utkal Deepika wrote, King Kurvanti na Kurvanti Kamini Vasaganara Yat Kamini Prasadena Nrupati Ghotokayate. And joke used to be, there are four kinds of Christian. Paddy, lady, pen, hen. Those who went to some relief, they became Christian. Paddy, lady. Somebody wanted to marry a lady, Christian lady, he became a Christian. Pen, hen. To study, you get some money, okay, you become Christian. Hen. Eating chicken was forbidden. So, to eat chicken, you become Christian. But Madhu Babu did not belong to any one of these categories. that be assured. He actually had joined Christianity seminars when he was in undergraduate, and his father went to Calcutta and he said, Tejya Putra Kali, I deprive you from all inheritance. So Madhubabu passed his BA examination, then he became a Christian, then he passed his MA examination, then he married Soudamini. Who was Soudamini? Soudamini was daughter of Pastor Jadunath Chatterjee. So our identity in Bengal those days was Mutia, Kuli, and even Madhusudan Das with a BA degree was known as Madhu Ude. Yes. So that was our identity. So imagine this educated girl probably passed her high school, okay, and she married this young man who was from Odisha and defied the social taboos. So Madhusudan Das married, okay, and Madhusudan Das did not have any proper job. He used to teach part-time in colleges, as was private tutor. In fact, he was private tutor of Sir Asutosh. Okay, that is how he lived. And Soudamini fell ill, and he did not have enough resources to give her proper treatment in Calcutta, whatever it meant those days. Okay, Soudamini passed away. Madhubabu was only 31 and he was a Christian. He could have married any other Bengali girl he wanted. Okay? He did not marry. Madhubabu did not have a photograph of Soudamini Das. You cannot find anything anywhere about Soudamini Das. And he had only a photograph of her tombstone till his death. No, actually, nobody talks about wife of Utkal Gaurav Madhusudan Das. Fact. Now, I am very proud that at least to this gathering, I have managed to bring name of Soudamini Das to the light. So, oh my neglected great grandmother, bless me wherever you are. I have tried to restore your rightful place in the as the daughter-in-law of Odias. And now I'll end with 3-4 anecdotes. It won't be very long. He was in the habit of being a very punctual person. So this I heard from my grandmother. So he went in evening walk. A king was to come to meet him. Kings used to stand by, okay, and king did not show up, so he went for his walk. When he came back, the king was waiting. So king gave the usual excuse, this happened, that. Madhu said, look at this wall clock. The minute hand even did not wait for you. Do you think Madhudas will wait for you? This is one. And he was also very famous for his wit. And there are many, but one is, again I heard, that Jankinath Bose, father of Netaji, spread some scandalous rumor that the judge called him to his chamber and kind of reprimanded him, scolded him. So finally it came to him. So one day in bar library he came to face to face with Janki Babu. So he inquired, what happened really? So he fumbled. Okay? So Madhu Babu was in habit of speaking Bengali at home. So he said, Janoki, tumi Janoki, তুমি ছেলে মানুষ তুমি জানো কি? So that is how it ended. And Madhu Babu's tannery was making losing money, so it came up for auction. And grandfather of Judge Sahib and many of his Madhu Babu's close associates, they saved this tannery. So that eventually Soilabada bought it. That is why the college is Soilabada Mahila College. Okay. That another one is shows how, let us say, what should I say? It's not a good word to say in public. His brother Gopal Ballabh Das fell very seriously ill. And when there was no point of return, Gopal Ballabh adopted Upendra Kishore Das, who was a painter and who actually has written Mala Janma. Okay? So, when Madhu Babu heard this, he became furious. He said, how can Gopal do this? How can he actually adopt Upa? Upa doesn't have blood of Sati in his vein. And he did not go to see his ailing brother till the last breath. Yes, it is true. And you see, very unreasonable argument. Now I am at the very end. Okay? Those who know me very well, you know that I am obstinate, I am uncompromising, and I am a bit arrogant. So, मैं क्या करूं? ये तो मेरे खून में है. Yes, same blood. So I'll end something which has given me guidance all my life, unfortunately in Bengali. তুমি যে আমার দিশা অকুল অন্ধকারে ভরাও আমারে ওগো নীরব অহংকারে.
Thank you so much, sir, for the thought-provoking remarks and giving us a deeper insight into the life of Sri Madhusudan Das and Soudamini Das. May I now request Dr. Pranay Swai, Registrar NISER, to introduce our distinguished speaker for the evening, Justice Ananga Patnaik.
Thank you. Sir, if you permit me, I'll take 30 seconds more. Sure. I don't know. I mean, working with Professor Maharana for last 1 month or so, sir, I'm sure the entire hall is moved. Your teary-eyed address left many of us moist-eyed. So I'll just take 30 seconds more just to invoke. I know it's not appropriate to invoke somebody else when somebody else's memorial lecture is being talked about. So let me invoke another proud Odia on this occasion. Durgama giri durga prachira jirna duare basi ডাকে তান্ত্রিক মন্ত্র সাধনে জাগ্রত পুরবাসী পৃথ্বী বিদারী বারবাটি মড়া উঠ উঠ চঞ্চল খোরধার শত সর্দার শির কর উন্নততর উঠ কঙ্কাଳ ছিণ্ডু শৃঙ্খল জাগ দুর্বଳ আজি উঠু হত গৌরব গত গৌরব হৃত গৌরব আজি. I don't know. I'm totally moved, sir. Your appeal, I'm sure, will bring question. My apologies for spoiling this memorial lecture with an invocation of Godavis Mahapatra. I'm sorry again. Moving on, Honorable Director, Professor H.N. Ghosh, Professor Ganadev Maharana, and Justice Ananga Kumar Patnaik, my colleagues, friends, invited guests, and students. It's a huge privilege for me to introduce Justice Ananga Kumar Patnaik, who has graciously joined us today to deliver the first ever Madhusudan-Soudamini Das Memorial Lecture here at Niger, Bhubaneswar. Well, to this part of the country, Justice Patnaik does not really need any introduction, though he deserves a long one. Justice Ananga, rule of law and constitutional values. He began his legal career as an advocate at Odisha High Court, where he soon earned recognition for his sharp legal acumen and integrity. In the year 1994, he was elevated as a judge of the Odisha High Court, the then Odisha High Court, marking the beginning of a remarkable judicial journey. Over the years, he has served in several high courts across the country with remarkable distinction. He was appointed the Chief Justice of Chhattisgarh High Court and later the Madhya Pradesh High Court, where he was widely respected for his fairness, clarity of reasoning, and administrative leadership. In November 2009, Justice Patnaik was elevated to the Supreme Court of India. During his tenure on the Supreme Court bench, he contributed to several important judgments that reflected his balanced and principled approach to justice. Even after his superannuation from the Supreme Court, Justice Patnaik has remained actively engaged in public life, contributing significantly to national debates on law, discourses on governance and ethics through various commissions, public lectures, and intellectual engagements. He's a proud alumnus of Rajkumar College of Raipur, Delhi University, where he did his BA in BA with Political Science honors, and then Madhusudan Law College. So the name justifies for this first memorial lecture. And to his credit, he has also been honored with the honorary doctorate in law from Utkal University. You can go to any search engine and look for his landmark judgments that he has been involved in, which, to name a few, many controversial yet remarkable landmark judgments: impeachment of Justice Soumitra Sen, interlinking of the reverse project, the 2G spectrum case, the Central Vigilance Commission inquiry against the then CBI Director Alok Verma. These few things just go on to reinforce the fact that Justice Patnaik has been a fearless jurist. It is therefore a matter of great honor and privilege for all of us that Justice Patnaik is here with us today to deliver the first Madhusudan-Soudamini Das Memorial Lecture, an occasion that commemorates the legacy of two remarkable individuals which Professor Maharana just narrated, and seeks to foster thoughtful dialogue on the issue of public importance. On behalf of Niger Bhubaneswar and also on my personal behalf, I reserve the great pleasure to warmly welcome Justice Ananga Kumar Patnaik and invite him to deliver the memorial lecture. We look forward to listening to his insights and wisdom. Sir, the floor is for you.
Very difficult to stand and speak for 1 hour at this age. Therefore, I'll beg apology to speak to you all sitting down. The director of NISA, Professor H.N. Ghosh, Dean of NISA, Dr. Pranay Swain, the sponsor of this lecture, Professor J. Maharana, many retired professors who are here amongst us, many existing professors of this institution, Professor Ved Kumari, who has come from National University, Cuttack. Ladies and gentlemen, and my young student friends, good afternoon to all of you. Now, first of all, let me tell you that I was also a student of science like you were. And only after school. That time my school was up to class 11 in Rajkumar College. Did very well in biology, scored very high marks, record marks in school. Then joined pre-medical in Delhi University, Hon'ble College. And after studying pre-medical for 3 months, I find physics, chemistry, biology so tough. So tough. I thought, let me get out of this. And therefore, all you students who are there studying basic sciences here, you are much brighter than what I was in your age. I couldn't take it. Therefore, I switched over to arts, to science. Then I studied law, and ultimately become a lawyer and then a judge. But then, constitution is a alien subject for me. Therefore, I will not speak in very technical language, a very complex language, but I will narrate the simple provisions of the Constitution related to fundamental rights. I am saying this because Professor Kumar is here. She must be expecting a big lecture. I am not going to do that. I am going to deal with basic provisions of the Constitution related to fundamental rights. As you rightly heard from Professor Maharana, my grandfather, Balakrishna Patnaik, who was a poet then, he worked with Madhusudan during that time. And in fact, he was made the person in charge of the chapter of Utkal Sammanini, which was opened in Bendkar, that is Badass Moja. And we have not seen Madhusudan. But right from childhood, my grandfather used to tell us, Madhu koi aichanti, pancho minute, deso pai, chinta karo. Did you know who Madhu was? But we were listening from childhood, didn't know who Madhusudan was. Until I studied in Madhusudan Law College. Law. Then I started reading about Madhusudan. The first book that I read was the abridged English version of Madhusudan by Surendra Mahanti. And I commend you must read about it. If you read about this gentleman, you can't believe that such an Odia, so committed to Odia, such a lawyer, such a brilliant man, such an honest man, was the leader in this. Now, when I compare our present leaders with Madhusudan, I find a level difference. Great leader. And then later on, I read another book very recently because it was published then. The Undying Legacy of Madhusudan. This is edited by Professor Jugal Kishore Mahanti, who was the chair of the Kids University. And in that book, there is one article by Professor Maharana. As he rightly said, nobody knew who Soudamani was. It is in his article that I read that Madhusudan Das got married to Soudamani in Calcutta, but at a very young age. He died in 30s when Madhusudan Das was in 30s. And then he thought there is no meaning for me to stay here and come back. He came back to Odisha for one thing. And those who are from Bengal, studying here, I am told number of students are studying from Bengal. You must know that Madhusudan Das was the tutor of Sir Asudas Mukherjee, a judge, a great Bengal leader who was called as the Lion of Bengal. And Madhusudan Das used to say, I tamed the Lion of Bengal. That was the language. And Mr. What you call Professor Marana never mentioned how he is exactly connected to Madhusudan Das. He is actually the great grandson of his brother. His brother's name was Gopal Malhotra. That is his great grandson. And he came to my house and made a request. I thought, why is he keen? Why is he keen? Then I came to know that he was a keen. And I immediately agreed. Then sent topics on which I could speak. I picked up this topic of fundamental rights and the Indian Constitution. And I tell you why. If you read even Surendra Mahanti and Madhusudan Das, you find Madhusudan Das was totally committed to justice. Not bothered about money. I'll give you a small example. Once was sitting in the bar, in the Cuttack bar, court bar. That time High Court had not been established. A Vakalatnama, Vakalatnama is a power that is placed by the lawyer before the court that I have been authorized by my client to appear. It was being circulated in the bar by a rich Mahanto. And the dispute was between Mahanto and a poor farmer. When it came to Madhusudan Das, he found everybody has signed the Vakalatnama in favor of the Mahanto. Then he asked the Mahanto, hey, everybody has signed, who will appear for that poor farmer? He said, nobody wants to appear, I want everybody's signature. You know, I will appear for the poor farmer. And I will find that. So, entire bar, all lawyers on one side, and Madhusudan Das on the other side, poor fellow. He won the case and he made a name for himself. This is how Madhusudan Das was known for fighting for justice. Therefore, the topic that I have chosen is fundamental rights. Because Madhusudan Das stood for rights. If you read the Constitution of India, the preamble, it's there. Can you read it? It's there. It says, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular republic, and to secure to all its citizens justice, social, economic, and political liberty, equality, fraternity, so and so. So this is just the preamble. This is the introduction. This is what the object of the Constitution is. How this justice will be given? The Constitution provided in Part 3 of the Constitution the various fundamental rights through which justice can be given to the people of India. It provided in Part 3 of the Constitution the fundamental rights. First of all, fundamental rights guaranteed against whom? Against the state. And what is the definition of state? Article 12 gives the definition of state. It says, state includes the government and parliament of India, and the government and legislature of each of the states, and all local and other authorities within the territory of India under the control of the government. So most of the rights, fundamental rights, are against these different branches of the state. The government and parliament of India, the governments of each state and legislature of each state, then all local authorities and all other authorities. Other authorities will let's say Airport Authority of India, any other authority. This is an authority. Niger is an authority. It's funded by the state. Right? So any student having any injustice being done by Niger, you can approach the court. Right? You have a fundamental right, remember. Right? You don't take everything lying low. Director said so, I can't help it. You have a right. You can knock the doors. Right? So, state is very widely defined for the purpose of fundamental rights. Then, laws have been defined under Article 13. And it says, basically Article 13 says, laws are very widely defined to include any ordinance, order, bylaw, rule, regulation, notification, custom, usage having in the territory of India the force of law. Very widely defined. And then it says, Article 13 says, if any law violates or abridges either fundamental rights, it will be null and void. You can't make a law which violates fundamental rights. This is how it is protected. The fundamental rights are protected. Then, why are they called fundamental rights? Why are they called fundamental rights? Because they are basic. Basic rights, number one. It has not been defined. Fundamental rights have not been defined. They are basic rights. The rights which are necessary for the growth and development of any personality. This is one. Second, these are mentioned in Part 3 of the Constitution. If you have to find out whether it's a fundamental right, these are mentioned in Part 3 of the Constitution. And third, these are enforceable in the court of law. These are enforceable in the court of law. They are not just rights in paper. You can go to a court of law and enforce it. You can go to the Supreme Court of India, you can go to the High Court, you can go to any court and enforce it. They are enforceable in the court of law. These are the basic features of these rights for which they are called fundamental rights. Now, The first fundamental right that they have mentioned is that, that the state shall not deny to any person equality for law or equal protection of laws within the territory of India. Two expressions. No person shall be denied equality before law. Which means before the law, everybody is equal. If the Prime Minister violates the law, he answers. He has to answer in the court of law. If grade 4 employee violates the law, he is answering. Everybody is equal. And in a court of law, the Prime Minister cannot say I am privileged. The Minister cannot say I am privileged. All equal. So this is called equality for law. And what is the meaning of equal protection of laws? When the laws are made, they should not discriminate. They should not discriminate. Laws should be made in such a manner that there should not be no discrimination. There should not be any discrimination. But if supposing salary is fixed by NISER and professors get very high salary, assistant professors get lesser salary. Then after that, because of that, some junior teachers get lesser, still lesser. Can the junior man go to the court of law and say, look here, equal protection of laws means my salary should be the same as that of the director or that of the professor? Equal protection of laws would normally mean that. So therefore, Supreme Court has said, we have said no. It means amongst the equals, equal. So equal protection of laws means it permits classification. Classification of persons and things. But when the challenge is made in the court of law, you should be able to justify with the court why you have made this particular distinction between a professor and an assistant professor. You should be able to say that, look here, professor is more qualified, he has got more experience, assistant professor less qualified, less experience. Therefore, we are giving, okay, therefore we are giving lesser salary to the assistant professor. So this classification is there. Classification is permitted under Article 14. And therefore, equal protection of law permits classification of persons and things. Right. In case of taxation, person who earns more pays higher taxes. Persons who earn less do not have to pay tax also. So classification is also there. That is permitted by the equal protection clause. Then Article 15. Right against discrimination. Right. It says that state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Now remember, some person is mentioned person, some person rights are given to citizen. They are two different things. Citizenship is granted. So, in case of Article 14 is person. In case of Article 15, is discrimination. Citizens. Therefore, it says, no citizen shall on grounds of only religion, race, caste, sex, place of birth, or any of them be subject to any disability or liability restriction or conditions with regard to, apart from the general discrimination that is prohibited under Article 15.1. Under 15.2, everybody will have access to shops, public restaurants, hotels, places of public entertainment, then use of wells, tanks, bathing ghats, roads, places of public resort, maintain only a part of state funds or dedicated to the use of general public. I don't know, many of the students are born much later, much better, much later. I don't know, perhaps, how untouchability existed, how caste system existed. Earlier, in the bathing ghats, they will not permit, jail caste will not permit the poorer class caste people to come and bathe there or use a bathing ghat or well. So all this was sought to be done away with by guaranteeing that every person will, irrespective of religion, caste, race, sex, place of birth, will have a right to use them. They will not be restricted. The right against discrimination. But then this does not mean that special provision cannot be made for women or children. So Article 15.4 provides for children and women special provision will be made. This will not amount to discrimination because they had to be lifted. They were disabled. They had to be lifted. Then later on they added that for backward class of caste, special provision may be made for advancement of any socially or educated backward class possibilities. Then for admissions, certain provision made, special provision could be made to bring them up. To bring them up. They're backward, to bring them up. So this can be, there are challenges in court. The court ultimately try to find out whether this provision is necessary to bring a particular caste up or backward class up in society. Vote next. Equality of opportunity in matters of public employment. Any employment that is public, and in private employment there is nothing as yet. Any employment that is public, state employment, public employment, it must be a public employment. Equality of matters, equality of opportunity matters of employment. That means they will take the exams, recruitment exams, they will be selected, they will be advertised, and they should be given an opportunity. No backdoor methods. Then, no citizen shall, on grounds of religion, caste, sex, descent, or place of birth, residence, or neighborhood, be ineligible for or discriminated against with respect of employment or office under the state. So, any of the grounds, this cannot say you are not any office under the state. Everybody is entitled. Then, they have provided that the state can make reservations. Reservations in for both at the time of initial recruitment, subsequent they said also for promotion, different posts they can make some reservations for backward class of citizens, which in the opinion of the state is not adequately represented. If a particular service is not adequately, if a particular caste or class is not adequately represented, for them they make these backward classes reservations. Next. What is it? We come to Article 17. Untouchability is abolished. That time, a lot of untouchability was there when the Constitution was made. As practiced in any form is forbidden, the enforcement of disability arising out of untouchability shall be offence. They have made it offence. Abolition of untouchability of act they have made. Then no citizen shall accept any title from any foreign state. This is very academic, it doesn't take place now. Then believe that. Abolition of titles have been also done. Earlier there used to be Sir, Knighted, Sir. All those things have been abolished. Now this is the most important article, Article 19. All citizens shall have the right to freedom of speech and expression. Now we are saying freedom of speech and expression is granted. It was not possible before the Constitution came in. You couldn't speak anything. Now it is freedom of speech and expression. Then you can assemble peaceably and without arms. But without arms. Then to form associations or unions or co-societies to move freely throughout the territory of India. Anywhere you can move, from Kanyakumari to Kashmir, you can move freely. To reside and settle in any part of the India, and to practice any profession or carry on any occupation, trade or business. These are the freedoms that are given. But there are certain restrictions. They are not absolute freedoms. There are restrictions. They are laid down in different provisions of Article 19, 2, 3, 4, 5, 6. Each of these freedoms have certain restrictions which the state can impose by law, but the restrictions should be reasonable. And they must have a link with area. For example, say in freedom of speech and expression, it says nothing nothing in clause A, subclause A of clause 1 shall affect the operation of anything law, prevent the state making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of sovereignty integrity of India, the security of the state, trade relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement. You know. And you will find, if you read the new penal code, it is there. Each of these are offences. There are restrictions. Similarly, in clause 3, 4, 5, up to 6, certain reasonable restrictions are imposed on each of the freedoms. Article 20, protection in respect of conviction for offences. No person shall be convicted of any offence except for violation of a law in force at time of commission of the offence. Act, charge, and offence. This is very important. First, to declare the law. In the law, say this particular act is offence. Then, if I do that act, you on me up. But you don't declare the law. You do some certain act, and then you say you have committed an offence. It is like, say, in your institute, neither no rules are mentioned. You can't do this, you can't do this, you can't do this, nothing. And suddenly a student does something. Not an offence inside the campus. And then why have you done this? Law is first announce it. This will be punishable. If you smoke inside the campus, outside, you will be expelled or you will rusticated. If you don't let know, suddenly you find you are smoking very light thing. Cigarette to kya karna hai? But suddenly you are taking your hold up for some misconduct. Sister, where is this? I only light cigarette. So, director must say, you need to see the rules. Did you admit it? Not supposed to smoke. If he has not made the rules, you cannot do it. You can go to a court of law. He never announced it. And then expel me. You should have put it in somewhere notice to us. Declare it. Must declare the offense. I hope I am not giving you ideas. Huh? Then, next, and penalty also should be mentioned. This much penalty. Like if you commit murder, life imprisonment, or death. If you don't mention, you mention only if you commit murder, only imprisonment 5 years. And suddenly you can't turn around and say, no, life imprisonment or death sentence. That's not. That makes it bad. That's the protection. First declare the law and the exact punishment, or what is maximum punishment. And then you can hold it. Then, no person shall be prosecuted and punished for the same offence more than once. Say, this is called double jeopardy. Guaranteed against double jeopardy. In your campus, again, I'll give you the example, you'll understand. In the campus, supposing you drink and you are punished. Yes, punished. Once you drink and you get the punishment. So what is the punishment? Some particular punishment is given. Second time you have not taken the drink. Again punished. Sir, I got punished. You can't punish me twice unless I do it again. This is where this protection is there. Not twice. Punish me only once. One offense, one punishment. Not that I have punished it, I have done one offense, and you are repeatedly reminding me and punishing me. One after the other, one after the other, one after the other, till you are there in the institution. This is what the protection is. I am explaining it to you in very, very simple terms. Right? No double jeopardy. And third, no person accused of any offense can be compelled to a witness against himself. Right? And this should mean a guarantee against self-incrimination. Unless your confessions are voluntary, you can't be compelled. You say that you have done it, like the police people do. No? You say you have committed the offense. Both of the chalo andar ko. That is not permitted. Unless you voluntarily say. So they'll take it out from on fear and they'll put it inside. No self-inflicted, so no self-incrimination. Then next, Article 21. This is very, very important. No person shall be deprived of his life or personal liberty except according to procedure established by law. So nobody's life can be taken away except by procedure established by law. How important it is. And your liberty cannot be taken away except by procedure established by law. This article was thought of originally that way. Nobody's life and nobody's liberty can be taken away except procedure established by law. Earlier was that only substantively law, it has been declared that this is an offense. Now this provision says not only declared offense, a procedure is laid down. What is the procedure? You will be arrested, it has to be investigated, charges have to be brought, evidence has to be laid, and then the court has to give a finding. Then only you will get to go inside. ऑफर्स कर दिया, पकड़ा, घुसा दिया, punishment हो गया. This is not possible. This is what the guarantee is. Right? And this article, this language of Article 21 has been expanded. Deprived of his life, life has been expanded to include environment. Without clean environment, there is no life. Without education, there is no dignified life. So right to education has come in. Right to clean environment has come in. Everything through Article 21. Many things have come because this is a very dynamic interpretation of the Constitution. The Supreme Court has expanded good health, right to health, part of life. So Supreme Court has gone on expanding this right to life and given a lot of expansion to this right. Now next. Protection against arrest and detention shall be present. No person who is arrested shall be retained in custody without being informed as soon as he may be of the grounds for such arrest. And most important, very important. If you are arrested by the police, first thing that you say, why you go? Ground for my arrest? What have I done? Why are you arresting me? Right. So the police cannot arrest you like that. Arrest you, what have I done? Otherwise, just imagine if that freedom was there of the police. Without any grounds, you can arrest. You can do hell. You can do hell with you. So you must ask for what are the grounds of arrest. And then second thing is, law shall be retained, denied the right to consult. All right, these are the grounds of arrest. Let me consult my lawyer. Of your choice, not any lawyer. Of your choice. And grounds of arrest be defended by legal practitioners of his choice. This is yet another right from the right. And two, every person who is arrested and detained in custody shall be produced before the arrest magistrate, who is arrested within the period of 24 hours of such arrest, excluding the time necessary for the journey before place of arrest to the court of magistrate, and no such person shall be detained in custody beyond the set period without any authority. Within 24 hours, they must produce him before the magistrate. You understand the relevance of this? Most students will not. I did not understand the relevance of this until I became a judge of the Orissa High Court and went to Guwahati. And I found Guwahati first day of my sitting, I read the brief. Army operations were going on there. 94. 10 petitions filed. 9 petitions filed. Civil language. There was a knock at the door. When I opened the door at 1 o'clock in the night, when I opened the door, I found 2 army persons. They have the power to arrest them. They looked for my son. Then they picked up my son and left. Children may disappear. Such kind of army police, they may disappear. To ensure that this does not happen, produce immediately for the arrest magistrate. So when the matter came before the court, we directed, all right, you produce all these persons before the arrest magistrate within 24 hours. And they have to produce before the magistrate. Or if they can't produce, they must explain. In many of these cases, what they explained, he was killed in an encounter. We never picked him up from the house. He was killed in an encounter. When he was firing her, he fired. What happens? If you give a lot of power to the persons with guns, okay? I've been posted in Guwahati High Court for 8 years in Northeast. So all these places, Guwahati, Assam, Manipur, Nagaland, Tripura, they're all like that. So therefore, this protection is absolutely necessary. This protection was there, therefore, if you say so, and it's come before the court. how important the High Court was, and how important the magistrate power is there. So everybody is produced for the magistrate. हाँ भाई किस लिए अरेस्ट किया है? Why you have brought him? Why have you arrested? The magistrate will ask. He is done success. Then the magistrate may pass on, go outside or remand, or but you must give justified reason why you have arrested. And that time your lawyer stands there. This is the protection. Then the other one is you don't have to go through the preventive detention. There's some exception there. Some preventive detention takes place. This law will not apply. Preventive detention will not for any crime or something to prevent you from disturbing the law and order. That's a victim. He will not go into that. There are also some protection mechanisms. Now Article 23. Right against exploitation. Traffic in human beings and beggar, forced labor, and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in the court. काम कराओ. This can be used by private persons also. पकड़ लिया इसको काम करो. Make him work like a slave without paying. This is also prohibited. Then Article 24. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. I missed out one, Article 21A. Article 21A. Anyway, there is one article, Article 21A, which was introduced, right to education. No. You see, what happened was, in Article 21, right to life is there, I said. And the matter came before the Supreme Court in Uni Krishna's case, whether right to education is fundamental. The Supreme Court said when it started it was not. But there is a provision in the Constitution and directive principles which says whenever your capacity, I'll come to that, whenever the capacity or economic capacity of a state improves, you must provide education. The Supreme Court said, now it has become part of Article 21. Right to life includes right to education up to the age of 14 years. Only Christian case. And this was thereafter incorporated as a fundamental right by an amendment, Article 21A. The state shall provide free and compulsory education to all children of age of 6 to 14 years in such manner as the state may by law determine. Now you find everybody is getting free and compulsory at the age of 14 years. It was not there. And it was not there. And this fundamental right was challenged, and I upheld it. As a part of my judgment, I upheld it. Then next also. Article 25. Right to freedom of religion. Subject to public order, morality and health, and to other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Any religion of your choice to practice. Whether Hinduism, Christianity, Mohammedan religion, Sikh religion, whatever. This is part of your conscience and part of your faith. You have total freedom to do it. Except when you can't, give a kirpan or a Sikh person is part of religion. But you can't use it and chop somebody's head and say this is part of religion. That public order has to be there, subject to public order. Morality and all that. Now, nothing in this article shall affect the operation of any existing law prevent the regulative restrict economic and financial matters, health. For all this, I think regulation can be permitted. So far as essential part of religion is not touched. Religious endowments and trusts, temples. Every subject to public order, morality and health, every religious denomination or any section thereof has the right to establish and maintain institutions of religious or charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. So religious denominations have that fundamental right to establish and manage them. This also for having the right. I spoke over Article 27, 28 is there. It says, no religious instruction shall be provided in any educational institution, only maintained out of state funds. Part of secularism. If the state is managing, the state is what we call state is funding a particular institution. In that, no particular religion instruction to maintain against secularism. The state has to be away from religion. It cannot be promoting one thing. Then, nothing shall apply to educational institutions which are administered by the state but has been established under that. Then, no person attending an educational institution recognized in the state or receiving the aid of the state shall be required to take part in a religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises at the same time without taking their consent, the consent of the child or consent of parents who can't take part with state's funding. Then minorities, religious and linguistic minorities, they are fundamental rights of the Buddha. Any section of the citizens residing in the territory of India or any part thereof, having a distinct language, script, or culture of its own, shall have the right to conserve the same. It can conserve this. No citizen shall be denied admission to any educational institution maintained by the state or receiving aid out of state funds on grounds of only of religion, race, caste, language, or any of them. Then all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. In making such law, providing for compulsory exclusion of religion, the state shall not, while granting aid to educational institutions, discriminate against any educational institution on the ground that it is under management of a minority, whether based on religion or language. So linguistic and uh, religious minorities have been given the right to administer, establish and administer institutions of the choice. Yes. These are basically the fundamental rights that you. Earlier under Article 31, there were rights that if the state takes away the properties, it must pay compensation. Earlier stage when Jamindari abolition was taking place, Jamindars went to court and the Supreme Court said, give compensation. When Jamindar, so much of land means how much compensation? Though, so the government thought we can't do Jamindari abolition then. So they got rid of this article altogether, Article 31, scrapped. And not only all this acquisition that was there, initial stage when they carried out, they saved these laws for challenge. 31A, 31B, 31C, challenges, bring out social reforms. You have seen these are the constitutional rights, fundamental rights. Where do you go for violation? You can go to two places. You can go to ordinary courts also, but better is either you go to High Court under Article 226 to enforce them. There is a provision under 226. There is a violation of my or you can go straight to Supreme Court if there is a violation of fundamental right. Because Article 32 itself is a fundamental right. Yeah, to enforce your fundamental rights. And that Supreme Court and the High Court will enforce it. Now, these are the basic fundamental rights. Let me tell you one thing. You will definitely have a question. Can these rights be taken away by an amendment? Right. Earlier, first view was of the Supreme Court Shankar in India. Yes. Any part of the Constitution can be amended under Article 360, including fundamental rights. Earlier view. Then Goloknath case came in, second view. Raja Ben said, no. Fundamental right cannot be taken away. Right. Then again, third case, Kesavda Bharti case, they said, no, everything can be taken. Fundamental right can also be taken away. But basic features of the Constitution cannot be touched. So you have to find out among the fundamental rights which is a basic feature, which is not a basic feature. Equality is a basic feature. Very difficult to find out. Each time a matter comes up, question that will come before the court is it a basic feature? It's a basic feature, it cannot be amended, it cannot be touched. If it is not a basic feature, then it can be amended. Right. So that test is there. You will find the courts can know, is this taking over a basic feature? If it is taking over a basic feature, equality for law, no longer there. Affects the basic feature. Equal protection of laws, no longer basic. Affects the basic feature. Article 21, scrapped, basic feature. But certain other small amendments may not take away basic features. So that test is now prevails. The 13th judge bench, 13th judge bench have laid down that basic features cannot be touched. And if a fundamental right falls in the category of basic feature, it cannot be touched. Now, very important question that arises. India was a poor country. Most of the people were poor. These are rights that are given. They can be taken care of. But what about socio-economic rights? What about livelihood? What about right to work? So these rights, why are they not conferred? Then the preamble you say socio-economic justice. Where is the socio-economic justice? It's a very important question. But at that stage, when Constitution was adopted in 1950, where were the resources? So they could not be made enforceable. Fundamental rights, as I told you, each of these fundamental rights I mentioned are enforceable in the court of law. Those which had to be deferred and could not be enforced, they were put in part 4 of the Constitution, called the directive principle of state policy. That's it. 36, 37. These are the directive principles of state policy. The provisions contained in this part shall not be enforced by any court, but the principles contained, are nevertheless fundamental in the governance of the state and be applied while making laws by the legislature and by the government. So, socio-economic justice was to be achieved only by implementing gradually the directive principles of state policy. As and when our resources come on, we become more prosperous. Right. Now we have become more wealthy. A lot of revenue. Part of it is being done. Part of it is being overdone. Freebies bhi aa gaye. Everybody is getting 10,000. Subhadra Yojana. They have gone to the other extent. They have money now, so they are giving it. So socio-economic justice was not enforceable, but it is given as part of the objects, as a political context, as a political program of the parties. So it is gradually it is expected that the process of democracy, the adult suffrage, the voting process, will grow up, governments will have governments, will look after the needs, social needs of the common people. That is how change will be. Unfortunately, somehow now the change is towards more of inequality. A lot of inequality is coming. But in my opinion, it should have gone towards more of equality. Somehow they have gone to the Western thoughts and brought in liberal thinking to that extent as to make the rich the richer. And some relief they are giving to poor, but they are not able to give as much relief as necessary. The latest statistics is the reduction of poverty has taken place in India. And many people have come up, right? But many have become very, very rich in our country. So this is some substance of fundamental rights. If any questions you have, I am prepared to answer.
Thank you so much. Justice Patnaik is kind enough to spend some more time interacting with you guys. So please feel free. Yeah, you don't get such occasions enough. I'll need a volunteer, couple of volunteers. You can pass on the mic. Come here. please feel free.
Good afternoon, sir. Sir, I have the question on we have the freedom to practice any religion. Do we also have the freedom to opt out of a religion if a person is born in some
To
religion?
walk out.
To opt out, yeah.
To walk out.
Yes, yes.
Yes, yes.
So why is there no option sometimes we see in many applications to
Many.
application forms like you have to fill religion or a religion. So,
You can say, I don't subscribe to anything. Nobody can do anything.
okay, thank you, sir.
I don't believe in God. I don't subscribe to any religion. Right.
Thank you, Justice Patnaik, for the insightful talk into the fundamental rights of the Constitution. I would like to say, the Constitution has gone under many amendments. Some of them being, of course, adding restrictions to the fundamental rights. So, I have a multi-part question. First one would be, how do these restrictions set a fine line to tread for both the parties involved, which is the union and the people? Second part, specifically talking about the Article 19 and subclauses and the amendments it has gone through over the years, like the first 16th and the 44th. Do you think has the Article 368 weakened the standing of the people through the following amendments? And I know this is like stretching quite far out of my academic boundary, but invoking I would Keshavananda Bharati case, even after the establishment of judicial review and basic structure doctrine, do you think the fine line is still skewed in the direction of the government? And in your personal opinion, do you think is that required to maintain a complex democracy like India, or have we diluted the constitutionalism over time?
No, Keshavananda case sets the right balance. Right balance. You must understand that when the Constitution made, it is made for hundreds and hundreds of years. Right? And so many changes take place in society. Right? And with times, what happens is, if you look at some of the provisions of the Constitution, you find it is standing in the way. For example, Article 31 was there. And there was Article 19(1)(f). In Article 19(1)(f), one of the freedom was from to hold, acquire, and dispose of property. And Article 31 provided that when the state takes property, it must pay compensation for the property. That doctrine of eminent domain and police powers. Now, Supreme Court time and again interpreted when the Jamindari abolition was taking place, that if you take away property, you pay compensation. That is what Article 31 says. And freedom to hold, acquire, dispose of, it is there in Article as 19(1)(f) as a fundamental right. You can't tinker with this. If you tinker with this, we'll strike it down. Right. And then ultimately legislature wanted to bring in change. How will the land go to the tillers? Jamindars continue to be rich. How would it go to the tillers? How will the person who is the tenant, who is the tenant of the land and cultivating, he is working hard, but he is not getting his due. The property belongs to Zamindar. He is taking it due, exploitation हो रहा है. So to bring about these changes for the poor, they said now these provisions have to go. So Article 19(1) has gone, and Article 31 gone, and certain amendments were also Article 31B, 31C, 31D. They saved some of the amendments from challenge. They saved it. But the Kesavamarthi case says that you can't resort to Article 38 to take away the basic features. In other words, you can't do away with democracy. You can't do away with federalism. You can't do away with equality. You can't do away with fundamental freedoms. Right? So Kesavamarthi has struck a balance. And mind you, Kesavamarthi, luckily, 13 judges only majority of 1. Right? If that judgment of even secularism is part of basic feature, if secularism was not part of basic feature, by now the present government in India would have scrapped secularism. Mind you, because the basic feature they cannot. They would have made this in the Hindu Rashtra. They wanted to make it Hindu. And interestingly, one of my judgments also says secularism basic feature, and delivered in 2014, just before this government came to power. It has maintained a balance. Supreme Court has maintained a balance. Basic feature there, it is maintained a balance. But some are still unhappy with it. Those who want to change completely. Some are not. But very difficult to change now. You require again 15 judges to change it. Now it is so well settled, very difficult to change it. Thank you.
Good evening, sir. I had actually three questions regarding some of the recent judgments by the government. First was regarding the Sonam Wangchuk case. He was just released after detainment of 6 months. So I just wanted to ask, when does freedom of speech and freedom of protest goes against national security, since National Security Act was applied on him?
Wangchuk case, you are giving a very bad example. Wangchuk case, if I was a judge, one notice, second notice quashed. I would have quashed that detention order and sent it back. And Supreme Court, government had to withdraw because the Supreme Court had no option but to quash it and told them you kindly reconsider. Wangchuk case was not a case where they could have detained. Right. So therefore, government always tries to shut your mouth. They don't like criticism. And that is why these provisions are there. And therefore, you have a right to go to Supreme Court. Supreme Court will test it. In most cases, government tries to shut you up. If you don't shut, they'll put you inside. But you have to keep on fighting. You have to keep on going to court and keep on fighting. And Supreme Court must strike down. Supreme Court should be fearless and strike it down.
Another thing regarding the right to protest thing, we signed a waiver in Niger, basically, that we will not protest against anything. So can an institute like Niger take away such a fundamental right of ours?
You can protest, no difficulty.
So they cannot.
If you are fearless, वो होगा, एक्सपेल्शन होगा, रेस्ट्रिक्टेड होगा, चले जाओगे, go to court. 2-3 साल के बाद फिर आओगे. You remember what is happening? What you call JNU now? JNU, what is happening?
Yeah,
they protested something and they are rusticated. Authority will have to do it, but the students have to do it. They exercise the might. You do it. then you have to take organized students. But if you think, it's not necessary enough, or let me finish my studies, I'll do it.
And last thing about another one of the change of the name of one of the schemes of government. How secularist is it to change Manrega to Ji Ramji?
Government has done it. What government scheme, government has done it.
But technically, it should not be done.
It should not have been done. My view is not necessary. Not only that, it's not the change of name. Change of name doesn't matter. Substance is that was giving a good right to give to states to do it. States are funding it. Now they have controlled it from the center. The new scheme is they will center, so they will decide where to do, when to do that. Not politics.
Thank you, sir.
It will have consequences. Mind you, the state governments will take advantage of this lacuna and may have an effect on the next voting on the next elections. People don't know what really works. Subsequently it works. Then मुश्किल क्या हो गया? गड़बड़ हो गया.
Thank you, sir.
Honorable Sir, the state can restrict our freedom of speech and expression, but if the state
Where is he? Yes.
But if the state works in their own political motives, the citizens have the right to go before the court and get justice. But there has been grievance of delays in justice in courts, even in the Supreme Court. Even bail trials had been delayed in some cases. Is this not a violation of our fundamental rights? And how can this be prevented?
No delay is taking place. I entirely agree with you. Right. Particularly when it comes to violation of fundamental rights, there should be, in my opinion, an exclusive bench in the Supreme Court dealing very fast. That all depends on the Supreme Court Chief Justice and judges. If I was there, I would say the exclusive bench under any Article 32 petition has to be heard and disposed of very fast. Right. That priority has to be given. They are not giving what to do. They are after human beings. They are all compulsion. If I was there, nobody thought of making me chief justice. They want to do it. Right.
So, hello sir, it was a wonderful lecture. So my question slightly deviates from the fundamental rights. So recently the Supreme Court of India banned the 8th class NCRT book because it talked about the number of cases and the corruption at different levels of judiciary. So basically, like in your opinion, like was this blanket ban right? And like if so, shouldn't we teach our students more about the flaws in our democratic system? Thank you.
No. What was written in the NCRT book? Obviously bad. Right. But once they took it out, no further thing should be done, in my opinion. Leave it to NCRT to do it. But they should not unnecessarily make a wrong picture of things. They will so much of corruption is taking place in government. Are they taking it out? Why don't they write? There is a lot of political corruption in government. Were they ever right? These are all done with motives. And the Chief Justice of India was right. Why it has been done? They want to paint the judiciary corrupt, and they'll be all right. Then paint everybody with black brush. Government is also corrupt. They don't write that. And NCRT book is not supposed to say all that. So first portion is all right. But thereafter pulling up everybody's, I think the Supreme Court has overdone it.
So do you think like we can allow that like the NCRT to criticize, like not criticize, as in tell about different flaws in our democracy, like corruption in both all the executive and judicial.
Not an NCRT book, you can talk about corruption. People are talking about judicial corruption. But teaching a student of class 8 about corruption, you have to come to judiciary. Is that correct? You can say there is delay in judiciary. All those things are there. It's already there. My grandson is studying in class 8. I have seen that NCRT book. But now the new book that has come out, it has put this new chapter.
Sir, we shall find many cases that are split judgments. That really confuses us because lot of subjectivity is there because it is not that objective. Many a cases we find split verdicts, and many a cases minority verdicts are more forceful than the majority verdict. So it really confuses us. The same set of circumstances, same set of evidences, and the judges differ. It is very, very painful for the general public to know exactly. That should be little objectivity in the judgment rather than that personal angle, personal feeling. Those pictures should not be taken into the judgment. That would be more objective judgment. My view is
Let me
that.
tell you one thing. Everywhere in the world, human beings are judges. Once human beings come in, subjectivity comes in. Right? When I was in the Guwahati High Court, everybody was fond of my court. They wanted cases to be heard by me, decided by me. When I came to Orissa, everybody was fond of me. I was committed to justice. Totally committed to justice. Right? And in Supreme Court also you find, I can say, when I was Chief Justice of Madhya Pradesh, I knew all my judges. But when I used to give the cases to a particular court, I used to think, who in which court this case will get benefit. So one matter came up. Election of Shivraj Singh Chauhan. I kept the file. He was Chief Minister then. I was Chief Justice. From this you'll understand. So, whom to allot? I want to ensure whoever is there, he is not aligned towards Shivraj Singh Chauhan. Then a friend of mine, Odisha, he arrived in Bhopal and said, I have come. Before I want to meet you. He will belong to BJP. So I thought now he has come to influence me. To have it before a particular bench. So I immediately allotted that to somebody who was not BJP person, very neutral judge. In the evening, he came to my house by car from Bhopal, right from Shivraj Singh Chauhan's house to my house, and said, that case, why don't you allot to Justice Pandey? Then I said, you should have told me earlier. Why? I have already allotted to somebody else. Right. And after retirement, first Pandey retired, he immediately got an assignment from that bench, from Shivraj Singh Chauhan government. So we know our benches. No human being perfect. Judges are also not perfect. And I was liked because I was thought to be impartial. You're talking about this one chuk. I said it was before me, I would have passed that order. Before Justice Oak came Bombay, he would have cautioned second day. But it was before judges who did not have the courage to caution. What do you do? And they had inclined that side. That is why government has a big say in appointment of judges these days. They exercise very carefully. Both in Indira Gandhi's time also they had a say. And now this time also they had a say. They ensure that their people get very few neutral judges ultimately get selected and appointed in the Supreme Court. Right? Yes. And the neutral judge impartial judge, basically he is objective. People are very fond of him because he is impartial. Judge is not known by his brilliance. Judge is not known by his intellect. A judge is known by his impartiality. I can take it. 5 minutes more.
Thank you. Thank you for your talk, sir. Sir, I wanted to ask, like, you said that basic features can be changed. So how we define basic features?
No, cannot be changed. Basic features
cannot be changed. So how can we define basic features?
See, if that Kesavadabhat case, they have not defined what are basic features. Right. But I'll ask you a question. You tell me, you nod your head and say whether you think it's a basic feature. Democracy is it a basic feature?
Yes, I think it is a basic feature.
Same way, justice is a basic feature. Federalism, do you think it's a basic feature?
Yes, I think.
Rule of law, do you think it's a basic feature?
Yeah.
So this way, this is the test. Right.
It is the public.
The perception हो जाता है, आस्ते आस्ते perception हो जाता है. हाँ. But supposing it's a, you will have doubts now. Parliamentary democracy is a basic feature. You don't know? You tested? You tested, discussed, then tested, discussed. Equality for law is a basic feature. Secularism is a basic feature. So basic feature test means they did not define it. They said as and when cases will come up, we'll decide. Right?
So can we say our constitution is not perfect?
कोई constitution तो perfect होगा नहीं. Nothing is perfect in this world. Nothing is perfect. You are a science student. Everything is relative.
Yes, sir.
Nothing is absolute. Right. All right.
Thank you, sir.
Thank you, sir. So I wanted to ask, why is right to education only until age 14? Why not 16 or 18? Like at the age of 14, the student will be in 8th standard or 9th standard. So why not at least till 10th standard?
Yeah. See what happened was, the only Christian case, the issue was why not professional education also? Somebody wants to study MBBS. Why should not have a fundamental right? Somebody wants to do engineering. Why not have a fundamental right? It's the only Christian case they said this cannot be fundamental. Resources are not there. Fundamental right means you have to enforce it. Education also requires enforcement. Na? You have to, if you provide education, you have the money, resources to give medical, each student, medical student, so much of money is spent from a teacher, from classrooms, from infrastructure, laboratory. वो पैसा रहना चाहिए. Now, if he says, I have a fundamental right to this, then he can go to the court of fundamental right means he go to the court and say, I have applied for medical, I want to study this, please enforce it. Court will issue a direction. The authority say, where is the money? Fundamental right for everybody. So at a certain stage, they said, let us take it up to class, up to 14. We can provide for everybody. Education up to 14 years, we can provide for everybody. We have the money, we have the resources. The state have the resources. India is developed enough to give this much. And thereafter, let them go for their own private resources.
Yes. Thanks. Good evening, sir. As you were walking us through Article 32, that was the right to constitutional remedies. Here you mentioned that everyone has the right to approach either the High Court or the Supreme Court. But we often find there are the two-tier systems of judicial reviews, one for the elites and one for the common people. So is the judiciary, by adding its own condition to a guaranteed right, creating a
What elite? What elite?
like midnight reviews for people with resources, but long queue for common people?
Yeah, that. That shouldn't happen.
Is that judiciary, by adding its own condition to a right, actually amending the constitution through the back doors?
No, there is no elite, there is no distinction. The fundamental right is concerned, it is available to everybody. Fundamental right and Article 32. The only thing is, Article 32 is a remedy where the Supreme Court. 226 also you can go to the High Court. Orissa High Court is here. Article 32